permission before you start recording someone. You don't have my permission to record. Nevertheless, I'm not going to stop the appointment regarding you doing something that, I'm not giving you permission for. The developments in the case are that the state attorney picked up the phone and started talking to the Taylors, and I don't know if they talked to Valentine yet, but they did talk to Michael Sr., and he was very rude to them about wanting to participate in the case and everything, and told them that they shouldn't be prosecuting you, and he didn't want to participate. Now, he's not a very important witness. The important witness is Valentine, and she's the alleged victim, and if they have some difficulty with her, that's where we're going to get some traction. And the traction is going to be that potentially they're going to make an offer for misdemeanor and time served, okay? And they haven't made that offer yet. I talked to them late last week and said that, I had an appointment with you this morning. We have pre-trials on Tuesday, and the appointment with you was very important, and I'd like to be able to convey some information regarding what an offer would be. And they indicated that they hadn't talked to Valentine yet, and so they didn't have any information. So that being said, I wanted to inform you about that and talk to you and your parents about the advantages of taking a misdemeanor offer. Advantage number one is that you're not going to be a convicted felon. Advantage number two, if the offer is misdemeanor, battery, and time served, it means that you have to pay a fine and court costs and, take care of the case, and you're not going to miss work. You're not going to have anything over your head like probation, and it's over. And actually you have a substantial amount of jail time in. You have, my calculation is about 9 months, including the time that you're in jail and the time that you're in the treatment facility, the state facility, which you should get credit for, and the state attorney agrees, because it's a lockdown facility. So 9 months is a lot of time, and that's something for them to, if they are inclined to make that offer, they can't make that offer unless they talk to a supervisor. So it's kind of a two-step process, maybe three-step if you want to include the fact that they have to talk to Miss Valentine. They talk to Miss Valentine maybe tells them to go fly a kite, or I don't want to participate, or I don't care what you do with the case. And then they go to their supervisor, and their supervisor says, okay, you have XYZ problems. This is the aggravated battery, it's a felony second degree, but we agree that you can work out the case this way. And then they give me a call, and then ultimately it's up to you to decide.
It's up to me to decide what?
Whether or not you want to take it or not.
Take what?
Well, right now there is nothing to take. Okay, there is no offer on the table. So I just wanted you to come in this morning to know what's been happening, so you're fully appraised of everything that's going on.
So what have you done in my defense?
I've done a lot. I've researched your case, and this is the type of case where I'm not going to, and this is something I'm not going to share on video or whatever. There are certain ways of handling your case, and there are certain ways of not handling your case. And one of the ways of not handling your case to kind of be general is to not push things, okay? Because if I push things, okay, that means that they're going to show up, okay? So let me describe this process to you. Your friend, what's your name?
Nisha.
Nisha. Let's say she's Miss Valentine, okay? And let's say Miss Valentine, she gets a knock on her door from the sheriff's officer saying, here's a subpoena to show up to the state attorney's office for a deposition. Well, it's a lawful command to show up, okay? So what are you going to do? You're going to disregard it, or are you going to go, okay? And when you come to the state attorney's office, what I'm doing is I'm helping out the state attorney, okay? I'm helping the state attorney find out about who Ms. Valentine is, okay? Ms. Valentine not only is showing up and talking to the prosecutor because he's there, but she's going to share her address, her cell phone number, okay? She's going to be aggravated by the fact that I, through you, or you, through me, made her show up to the state attorney's office. And it's going to make her say, well, if we're going to play this game, then I'll show up for trial too, okay? So there's ways of handling things.
Wait, I got a question regarding that.
Okay, let me just finish because this is kind of important. That's the way of not handling it when I already know what she's going to say. I already know what she's going to say. I already know what her criminal record is. And if if it's that the state attorney's bugging her, okay, the state attorney's calling her up and saying, you need to do this, you need to do that, she can say to the state attorney, go fly a kite. I don't want to be involved. This case is a couple years old. You know, I'm working. I have kids. Leave me alone. And then she says to that him over the phone, and he has to make a decision whether or not to send an investigator out to go track her down. Okay? And if he does that, it's only going to make her less inclined to participate in your trial. And on the back end of all this, it gives you options. Okay? So I've been handling cases for 20 years. I know how to handle a case when you have clear testimony on both sides about what happened. I don't need to do a deposition to find out what she's going to say. I don't need to do a deposition to, you know, find out what the nuances are. I need her to disappear, okay, to get you some options. And the more likely it is that she don't want to participate without me doing anything, okay, because if I do anything to make her disappear, that's going to backfire completely on you. But if she just disappears naturally, you get an option of misdemeanor with time served on the table. You know, that's something that you should grab like it's $1 million, okay? So what's your question?
What law? Have you read the Speedy Trial Rule?
Yes.
So burden of complying with the Speedy Trial Rule, is that on me or is that on the state?
You have an attorney, okay? So I make the call whether or not I'm going to demand speedy trial and whether or not I'm going to waive it, okay? Your case already had speedy trial waived before I even touched it.
I never signed any waiver for speedy trial. And even if I had, even if a defendant waives their right to speedy trial, they can always reclaim that right by having their attorney file a notice of expiration of speedy trial time and a motion to discharge.
Ma'am,
if I do that, if you did that, if you would finally do that for me, that means the state has how many days to bring me to trial?
60.
No. 10.
No.
15 days if they were to file a motion with the court. 15 days max. If they file a motion and we go to court, and that judge allows the state more time to prepare their case according to the Speedy Trial Rule, based on those guidelines, if the judge allows them more time to prepare their side of the case, then I would have 90 days. They would have 90 days. The state, the burden of complying with the Speedy Trial Rule is on the state and not the defendant. So the state would have 90 days to bring me to trial. Yeah. Now, you've been on my case since September of 2014. It's now the February 1st, 2016. You sat on my case for over 6 months.
Ma'am, there hasn't been any sitting involved.
Over 6 months, you then wanted me to see a psychologist.
Ma'am, they found you incompetent to proceed.
When?
Okay?
When?
I don't have the exact date, but you've been found incompetent to proceed. You had competency training.
So am I competent now?
Yes, through a second round of discussions with you, they ruled that
you're... So when did they find that I was incompetent? What year was that?
Ma'am, I have your whole file right here.
What year was that? 2012, right?
I can answer questions, okay?
And those same two psychologists
But you have to give me a second to even talk, okay? You know, because it happened to you, that you were found incompetent to proceed. You know, because it happened to you, that you saw additional 3 doctors subsequently after you had competency training to find that you were competent to proceed by 2-to-1 vote. Okay, so you had a split decision regarding finding you competent to proceed. That is very important. Okay, there's no way in the world that a person who's incompetent to stand trial should go to trial. That would just be an injustice. Okay. So we're not going to do that.
What would be an injustice again?
For an incompetent person to go to trial.
Now, why did you want me to see the psychologist to begin with?
Because I wanted to make sure that you're competent to proceed.
What
to prevent there
from
being an injustice.
That I was incompetent.
That you're paranoid. That you don't get what we're talking about. That important things about your case don't sink in about how things are working. and the fact that you were previously adjudged to be incompetent to proceed. And each of the doctors have made findings regarding your ability to understand the trial procedures, and those are concerns that not only I have, but the psychologists have. Okay, you have the reports. I gave you all the reports, and you can read them, and you should take heart in them. Okay, in the fact that there's some avenues of treatment that they're recommending, and these doctors are very good doctors. They would be happy to work with you now and in your future. But this is something that like I said, it would be injustice for you to go to trial if you're incompetent to proceed. And that's just not allowed in court, and it's not allowed for a good reason, is that we want people to understand what's happening regarding the trial preparation, regarding what's happening in court, what's happening with the judge, what's happening with everything, for them to understand the system and participate. Okay, because it's going to affect you. Potentially, your liberty is going to be taken away.
What did I do in your presence, or say in your presence, or over the phone, the countless emails that I've sent you since September of 2014, indicated to you that I needed to be evaluated by a psychologist to push this case now, well over a year later?
There are legal and emotional issues which I've seen from you that have indicated to me that you just don't get it.
Get what?
You don't get how the system works, that you don't get, that you don't have any faith in what the judge or I say to you, and it's kind of a paranoid delusion that you have regarding what we're trying to do to assist you.
So am I being paranoid and delusional right now?
Somewhat. I see some of the indicators right now.
What have I said right now within these past few minutes that would make you think that I'm paranoid and delusional?
Usually when I tell a person that they potentially, and I'm not saying this without stressing that it's very close to being apparent, because I don't want to raise people's hopes up, that you're going to have an offer of time served and a misdemeanor. Usually people say, thank you very much. Let's make that happen. Okay? Instead, the next issue, that you just kind of dismiss that like it's completely not important, and wanted to focus on, doing a demand for speedy trial, which we've already covered before, and I've already described to you that you previously waived speedy trial, and that you didn't have a good reason to recapture it with the demand.